Thank you very much. I would like to thanks for warm welcoming organizer, dear professors, dear PhD students. It is my privilege and my pleasure to have opportunity to provide you small overview about Croatian joint stock and limited liabilities companies. My presentation will be divided in a few different areas. First of all, I will give you short introduction and history thing. After that, typology of companies, legal capital and finance, after shares and dividends, and some view of decision making in general meeting and management of companies in Croatia. The Companies Act is a fundamental legislative instrument that regulates the formation, internal relation in companies, representation, liabilities, operation and termination of companies. Its excellence and its compliance with other laws that regulates both the relation between market participants and cooperation of public authorities in the economy are the base of realization of free market. Since it has been in force since 1995, it is one of the more permanent regulation adopted in the Republic of Croatia. That Companies Act was amended and supplemented 16 times until now. Concerning companies are constantly developing, transforming and changing. The way in which the members of the company are bound together in private law community that makes it up is one of the features that distinguishes partnership from cooperation. In the case of partnership, general partnership, limited partnership, and economic interest grouping, their connection is of the personal nature. The members are personally connected only on the basis of the memorandum by which the company is established in order to achieve a common objective which they determine as a company's objective. However, the case of cooperation, joint stock company, Aktiengesellschaft in Deutsch, Dioničko društvo on Croatia, and limited liability companies, Gesellschaft mit beschränkter Haftung in Deutsch, and društvo s ograničenom odgovornošću hrvatski on Croatia, members are linked to the private legal community on the basis of stocks and share contribution, in which their membership rights in the company are embodied. The essence of cooperation is the association of members through capital. For this embodiment of membership, it is essential that each of them participates in the share capital of the company, and from this follows the scope of the rights and obligations that members have in the company. By transferring shares or share contributions, the member leaves the company and the acquirer joins the company. This transfer in the corporation is liberal, and thus the company does not change, only the composition of its member changes. From the perspective of historical background, the legal statutes of subject of commercial law in Middle Age was based on customs and statutes of Dalmatian cities. There were various types of partnership in trade, agriculture, shipping and fishing. But as you know, we were part of Croatian-Hungarian kingdom, and almost 8th century we were together, and Croatian-Hungarian settlement placed the regulation of trade relation under jurisdiction or joint Croatian-Hungarian parliament in 1865 codified commercial law by adopting a Croatian commercial code. That commercial code for those time was a modern law based on Handelsgesetzbuch, German commercial code from 1861, and Allgemeine Handelsgesetzbuch, Austrian commercial code from 1962. Croatian commercial code introduced general partnership, limited partnership, joint stock company, and cooperatives. After that, no new commercial law was enacted in Croatia, and existing commercial law was not changed or supplemented even in the new circumstances. After dissolution of Habsburg monarchy, 1918, and in the first Yugoslavia, Kingdom of Yugoslavia, introduced new draft of commercial code, but never came on force. And that situation on Croatian commercial code was in force until 1945. But after Second World War, in the Socialist Yugoslav Federation, the basic law on state enterprise from that administrative management of economy is introduced, and in totalitarian socialist spirit based on the basic law on private commercial activities all listed commercial companies are abolished. Upon the termination of the existence of those trading companies, the membership rights of their members cease, and the size property is managed by public socialist authorities. With such not only legal violence began a period longer than 4 decades for a socialist concept of social property, in which Croatian law no longer knew the forms of legal entities based on ownership, and there was no companies almost 4 decades. And after that, before dissolution of second socialist Yugoslav state by constitution amendments from 1988, the constitution gave certain powers to the person who invests capital that he was enabled to participate in the management of legal entity. The legal authority over the funds that were previously owned by the company was identified, so that on this basis he is also recognized with management rights and the association of labor and capital through a self-management agreement. This, on this basis, was created for the adoption a new law of companies which entered on force January 1st, 1989. With the returns of companies, the door of free market economy was left ajar, and concepts that has been regulated until then, such as, for example, private law association, stake, property, membership rights, profits, etc., returned to our economy. But that law was extremely sub-regulated because it contained only 52 articles, and there is no discussion about to change that law. We introduced after dissolution of second Yugoslavia, after establishing Republic of Croatia as sovereign state, we established new law, and new law on companies because such deficient regulation that is correction of that bad under-regulated law was impossible, and it was out of question. And in 1993, a completely new law was passed that regulated commercial companies in Republic of Croatia. The Companies Act had vacatio legis for more than 1 year and entered into force on January 1st, 1995. And today is one of the more permanent regulation adopted in the Republic of Croatia. The regulation on commercial companies had to be adopted according to the model of developed countries of the West, comparing the laws, judicial practice, and legal literature of individual European countries. It was acceptable to refer to the experience of Central European legal circle. German law was chosen as a model law, which, at the law of the leading member of the European Union, had the strongest influence on the development of companies law in all Central and Eastern European countries. And the Republic of Croatia had intensive business ties with that country, and the largest number of foreign investors came from it. Commercial companies are constantly developing, transforming, and changing. And so the dynamic development of companies law encourages the legislator to react. And as I said, 16 times until now, the Companies Act was amended and supplemented, as you know. Concerning typology of our companies, Companies Act provides the legal forms of commercial companies in such form as: first, joint stock company, Aktiengesellschaft, limited liability companies, Gesellschaft, GmbH, Gesellschaft mit beschränkter Haftung, general partnership, limited partnership, economic interesting group. That is numerus clausus, possibility for every investor to establish company. That's 5 companies are on view. But in addition, it is possible to establish a European joint stock company and European economic interest group in accordance with the directly applicable provision of European law. The fact that commercial companies are numerus clausus, however, does not mean that the same rules always apply to all companies of the certain legal forms. Sometimes, if such is the judicial political assessment of the legislator, special provisions are prescribed for performing of some special activities, and general provision which are valid for all companies of that legal form are applied unless those special rules stipulate otherwise. The reason for such an approach lies in the assessment that these are activities that are so significant and sensitive that they need to be regulated additionally, and therefore additional provisions are prescribed that apply to the legal form of the company in which they can be performed. In this way, for example, the regulation of banking activities, insurance activities, sport activities, etc., of participation was handled. But it is important to always keep in mind that this is not some new special form of company, but it is only a warning that this joint stock companies performs a special regulated insurance activity, and that in addition to the general ones, some special rules apply to it. According to finance the company, legal capital is the key term for Grundkapital in Deutsch, temeljni kapital in Croatia, and for member of joint stock company and limited liability company contribute money, things, and rights to it when it is established. It is impossible to establish joint stock company or limited liability company without that contribution. More often money is contribution, but things and rights are also possible. By investing their capital on company, the members shape the enterprise through which the company appears on the market and achieves its goals. Long-term profitability has a beneficial effect on the increase of assets, but unsuccessful or risky operation can reduce assets and ultimately even lose them if the company goes bankrupt. In addition to financing by its own capital, the company can also be financed by external capital obtained by creditors. In our economic practice, companies are often founded with the minimum share capital in order for members to reduce their entrepreneurial risk and are financed by other people's capital, not their own. For example, by taking loans. It is not an easy task to balance the different and possibly conflicting interests of the shareholders who provide it with its own capital and the creditors who finance it by loans. Since companies are most often financed by their own and other people's capital, creditors are, with regard to the possibility of failure of the entrepreneurial venture, more exposed to risk compared to the members of the limited liability companies, which can directly affect the operation of the company. That asymmetry has a theoretical explanation, but we have no time for that. Capital maintains the funding of company along with the distribution of profits, and the state of crisis is the central point of creditor protection, where the interests of shareholders and creditors are direct in conflict. Companies law deals a lot with that special conflict between members of companies, between companies and member of the board, management board of companies, and between companies and creditors, and lots of provision of company. Our company law deals with that issue. I will say a few words about the dividends and the shares. Force of all the shares, the legal regime of shares. The share capital of joint stock companies is divided into shares. Each share represents an appropriate part of the company's share capital. If shares with the nominal value are issued, the sum of their nominal values must correspond to the share capital of the joint stock company. Share rights can be divided into management and property rights. In a way, the most important management rights is the one that gives the right to vote on the general meeting of the company. More will be said about this when we will discuss about joint stock company, but there are basically two classes of shares. Share can be registered only in a name in Croatia. There is no possibility to issue share without knowing the name of the investor in that company. All investors in Croatia we have approximately about 2,400 joint stock company and more than 1,000 limited liabilities companies, and all members of all that companies are known because the share can be issued only on name. There is also a big, huge discussion about possibility of commission works and so on. Concerning the decision making in general meeting, a few words about joint stock company. Persons who are considered shareholders have acquired these statutes on the basis of their contribution to the company. Shareholders act in the company through the special body, so through it they are primarily authorized to make the most important decision for the status and fate of the company, such as, for example, those on changing the company's business and economic purposes, the statute changes, as well as those on the termination of the company. As a rule, they do not have direct authority to manage affairs and management in the company, and they can exercise their management rights only in the body of the company in which they operate. Management board is the operate body for the managing the company. As far as shareholders are concerned, the principle of equality of shareholders is a fundamental rule in the public limited company. This means that shareholders with equal condition must have equal rights and obligations in joint stock company. The position of shareholder must not be influenced by the circumstances of who the shareholder is and what his personal characteristics are, but must be determined by the amount of the shareholder's stake in the company. Amount of money invested in the company correspond with the rights of that investor in that company, and that is basic rules of management in Croatia capital companies. Few words concerning management of the company and structure of that management. Croatia law, there are two concepts of the organization of organs of joint stock companies, namely monistic and dualistic concepts of organization of the organs. The monistic approach, there is no strict separation of the management of affairs from the supervision of management of their affairs, because the supervision is not carried out by persons who would be clearly separated from those who manage the affairs of the society, of the company. The bodies of the company are the general meeting of shareholders, which includes the shareholders and the board of directors, as the body in which are those who manage the company affairs and those who supervise the business, the same organ. The management of joint stock company consists of one or more natural persons whose member is determined by statute of that company. It can only determine the minimum and maximum number of members, and in practice small company has one or two members, bigger company, insurance company, banks and so on have even 10 or more directors of member of that board. Management board members do not have to employ by the company. This is not recommended because it creates a labor law relation between the board member and the company, which may not be suitable for that function. Regardless of that, and without delaying into discussing this issue in detail, it should be mentioned that the relationship between the board member and the company is certainly twofold. On the one hand, it is based on the statutes legal basis, and on the other hand, on the contractual legal basis. The statute and legal position of the board member is based on the appointment of the board member by the supervisory board or a court. The contractual legal basis of the position derives from the contract on performing on duties of the member and management that person concludes with the company, that is management contract in appropriate for those business. To conclude, in Croatia we have 5 different legal forms to perform some business and achieve some business goals. 2 of them are capital companies, limited liabilities, and joint stock companies are capital companies, and more than 95% of all companies in Croatia are that 2 companies, mostly limited liability companies, more than 1,000 companies, 2,500 joint stock companies are established in Croatia. Some of that companies are established ab initio, new businesses, but some were in process of transformation of ex-socialist entities, enterprise entities by special laws, and they became either Aktiengesetz, joint stock companies or limited liability companies. And as you seen through my presentation, our connection historically and so on with Austrian and Hungarian had a big influence in our state decision to have German Austrian law as example on which we base our company law in Croatia. And if you read Aktiengesetz or GmbH-Gesetz, you can just see nearly the same structure. But there is no different law for each company. All companies, all 5 companies is one law. Companies Act constitute all company are in our Companies Act. For any further question, please don't hesitate to ask me. I'm here. Thank you.